Now, for more on the Supreme Court, here to discuss the legal implications of the birthright citizenship case is former Indiana Attorney General Curtis Hill. Curtis, great to have you on the program with us.
Thank you for having me.
So, the Supreme Court today weighing President Trump's order to end citizenship by birth for children of illegal immigrants. From a legal perspective, first, what's the reasoning behind this, and what are the judges here really considering?
Well, you're talking about a provision that comes from the Civil War era itself, a provision that provided for the former black slaves to be given citizenship based upon birth. It wasn't intended to be an immigration issue, certainly not as it's applied today. So the issues become, if you look at the language in the actual provision, are these individuals subject to the jurisdiction of the court? And the position that would support the executive orders would say absolutely not. That these are children who are born here to illegal parents who had no jurisdiction to the court, so therefore they don't belong in this country. I think it's a very strong argument, but on the other side you have those who would suggest that there's been 150 years of precedent that would suggest otherwise.
And now it also appears that even if the court does end up blocking the birthright citizenship order, they may still limit the ability of the judges to curtail the president. Judges have issued over 40 national injunctions since President Trump began his second term. Explain for us here how this works and what it would mean if SCOTUS actually rules on this.
Well, that seems to be the biggest question in this particular ruling today is what to do about the nationwide injunctions. And it's a very serious problem. It's a constitutional crisis. To allow one federal district judge to have that much power really tilts the balance of the balance of government. So it's imperative that the Supreme Court come down on limiting the scope of a one or a single federal district judge. We're seeing it in cases where one action is stopping the executive authority of the president in its tracks, and then we're getting mixed signals from one district court to another district court. So this is a very important time to for the court to take action, limiting the lower courts so that we can have a fair and equitable balance between our federal government partners.
And meanwhile, in another high profile case today, a Wisconsin judge Hannah Dugan pleaded not guilty to obstructing ICE agents. She's accused of diverting them away from a legal immigrant who was in her own courthouse and letting him out a side door. Now she's claiming a judicial immunity. First, explain to us what is judicial immunity and how strong is her defense in your opinion?
Well, judicial immunity is rightfully a protection to given to courts that allow for judges to have latitude in how they conduct their jobs. And typically, judges have control over their courtrooms, uh, every aspect of what goes on. But this is outside the scope of typical judicial immunity. Um, it's one thing for a requirement that a judge cooperate with the federal government. That's not what we're really talking about here. The allegation is that she opened up the side door and let the guy out, basically facilitated his escape from what was known to be custody. That's specifically opposing a federal agency. Uh, I don't think there's going to be immunity for that particular action.
And finally, back to the Supreme Court here. A ruling by the justices today could make it easier to accuse police of unreasonable force. And this was a unanimous decision about considering the circumstances in the case of a 2016 shooting. Why did they make this ruling and what impact could this have?
Well, this was a case that involved what's called the moment of threat. Uh, for the Typically, the courts are looking at a police action shooting, and they're able to consider only the moment of threat uh, for consideration as to what should occur and how liability should apply. This expanded action really, and I like it. I think it's just it's very suitable for police actions, for police officers who do the right thing, to want to have all of their activities, all of the actions be scrutinized. So what it does is it expands beyond simply the moment of the threat and allows the trier of fact to examine all of the events that happened prior to and subsequent to the actual shooting itself. I think that's a solid standard. I think that any good police officer would want the entirety of the circumstances to be reviewed, and I think the justices, by unanimous decision, agreed.
And finally, back to illegal immigration here. The justices are also considering the Trump administration's request to end humanitarian parole for over 500,000 people from Cuba, Haiti, Nicaragua, and Venezuela. What is the status of the administration's legal battles right now over using the Alien Enemies Act to deport alleged gang members?
Well, again, because of the single district judges being able to have such power to create nationwide injunctions and such, you've got some judges that have suggested that the president doesn't have the authority. Just yesterday, we had a judge, a federal judge, that said that the president did have the specific authority and laid out a framework to provide for due process in the process. So what we really need to see is the Supreme Court step up and engage into this process so that we can have this settled once and for all.
Well, very timely insights here. Former Indiana Attorney General Curtis Hill, thank you so much for joining us.
Thank you.